Welcome to another edition of Matters of Law. Matters of Law, the law reigns supreme. I guess you watched our repeated editions and you really enjoy them. Yes, we are back. Today, we are talking about the Juvenile Justice Act 2003, Act 653. Let's go for a spot of commission.
This program is brought to you by PEG Enterprise. Call us on 0240-533-097, 0240-533-097 for your delicious pastries, cookies and drinks. Locate PEG Enterprise near KK House in Ho.
Welcome back. We are talking about the Juvenile Justice Act 2003, Act 653. First of all, somebody will ask, who is a juvenile? According to the law, a juvenile is a person below the age of 18 years who is in conflict with the law. So any child below the age of 18 years who commits an offense, obviously, it's in conflict with the law. Now somebody will ask, will an 8-year-old be considered as a juvenile? Obviously not. The age for criminal liability is 12 years. So anybody below the age of 12 years will not be criminally liable for any offense that's been committed. But between 12 years and anything less than 18 years, that person falls within the range of what we refer to as a juvenile. Now, when a juvenile commits an offense, what are we supposed to do? How does the law treat that person? Juveniles are a special set of people that the law has made provision for. And according to the law, the welfare principle is what has to be adhered to. By that we mean, we want to ensure that we take the best interest of that particular juvenile or that particular child. So when a gentleman of about 13 years or 14 years steals your item, you gently have to take him to the police station. Now in the police station, the law requires that he must not be kept in detention with adults. At no point in time should he be detained with adults. Now, there's a process to also get them to court. At least their guardians or their parents must be brought. The juvenile must be informed in a language he understands the reason for his detention or the reason for his arrest. And remember, once all this is done, they have to do an interviewing process to find out exactly his response to whatever accusation has been leveled against him or her, as the case may be. Now, getting that person to court. The requirement is that juveniles are supposed to be brought before juvenile courts. Now, juvenile courts are made up of a judge and a panel. Majority of these panel members are social welfare officers or community members who sit in the session of what offense the alleged juvenile has committed. I must make the point also, however, that if a juvenile commits an offense with an adult, that juvenile and an adult may be put before a high court or a circuit court or any other court of summary jurisdiction. Now, when the courts make a decision or make a determination, the court and finds that person guilty, the court will remit the juvenile or will ask that the juvenile be sent to the juvenile court for purposes of sentencing. That is when the juvenile commits an offense with an adult. That is somebody above the age of 18 years, according to the law. Now, if this juvenile commits an offense alone and has been brought before the juvenile court, the processes require that there should not be a police officer who is in uniform. In fact, everybody is supposed to be dressed in mufti, not in uniform. The processes are also in such a way that it is the best interest of the child who we are looking at. So if that child has not been released on bail, that child can be given to his parents or that child can be given to a guardian or any other person who is fit to take care of that child. In the absence of that, that child has to be put before a remand home. Remember, not prison or police custody. That child must not mingle with the others. Now, it is also important that the trial process must be quickened, and the process must not last more than 6 months. Because if it does last more than 6 months, there's a likelihood that the case will be struck out. These juveniles have various punishments that will be afforded them or will be given to them if they are found guilty. For very serious offenses, they may go to jail for a maximum of 3 years. Here we are talking about murder, rape, manslaughter, and other offenses like that. There may be other offenses where they may be given lesser sentencing. At the end of the day, or even before the sentencing can even be given, the Social Welfare Department would conduct what we call a social enquiry report to find out the situation of that particular juvenile and establish how that juvenile got to that particular position, just to ensure that we understand the circumstances governing that particular juvenile and leading to he or she committing that particular offense. Juveniles are supposed to be taken very good care of, and we urge all parents that whenever they have juvenile delinquency or whenever children are misbehaving, they are properly counseled. We must take care of them, but we must ensure that they comply with the laws. Thank you so much for watching this edition of Matters of Law. Catch us on extvgh on YouTube and Explore TVGH on Facebook. Thank you for watching. See you next time.
To support this program, contact XTV on 024 606 1095 or 050 836 4159, or send us an email to info@extvgh.com.